back. It's always a delight when we have time to sit down with somebody I highly respect, Jim Burling. He is the Pacific Legal Foundation Vice President of Legal Affairs and the author of a fascinating book called Nowhere to Live, The Hidden Story of America's Housing Crises. And there's a picture of the cover of the book. He does have a website for that, nowheretolive.org. And I think out of his own passion on this subject, he's done an excellent job in telling you about all this. Also, pacificlegal.org is the website of his organization, pacificlegal.org. Jim, good to see you, friend. How are you, bud?
Hey, it's great to be with you again, Perry.
Thank you. Thank you. Thank you. Good to see you. Well, just quickly, the court wrapped things up. What do you think about this last go-around?
The court is having some good and interesting decisions. I mean, just today they ruled on behalf of a woman who had argued she was being discriminated against because she was a straight woman in a county office that had homosexuals working there. And she alleged that she was discriminated against because she was straight. But the courts, the lower courts, had said, well, look, this is out of the Ohio Youth Services, and Ms. Marlene Ames is the person who sued. And Marlene Ames said, look, I'm being discriminated against. I want to be held to the same standards as everybody else. But the court said, no, because you're straight, you have an extra burden of proof that you have to show that you've been discriminated against. And this extra burden means that you have to show there's kind of background discrimination where if a person was suing on saying that they were gay and being discriminated against, or that they were a minority and were being discriminated against, didn't have to reach that high level. And the Supreme Court unanimously said, in an opinion by Justice Brown, that it doesn't matter if you are part of one class or another. Everybody has the same standard of proof in trying to prove discrimination. Now, whether or not she could prove discrimination is a whole other matter. It's going back to the trial court for that. But the court is showing that it is relatively reasonable and conservative in a lot of its opinions. And that was a unanimous decision that came down this morning. So it's not just an ideological litmus test, Democrat, Republican, and everything. Some issues that the court can agree on, and that's treating everybody fairly right now.
Wow. Do you think the DEIing is going to stick?
I think the DEI has seen its heyday. And I think people are going to look at it. Look, of course, we have to make sure we do not have circumstances where people are basically handicapped because of their race or other things as well. But at the same time, we shouldn't bend over backwards and do reverse discrimination or say that if you are not a member of a particular discriminated against class, then you do not have certain rights. No, I think that the idea that we want to make sure everybody is treated fairly is always going to be with us, and that's going to be front and center. The idea that we should bend over backwards and discriminate against some people because they were benefited from discrimination in the past, that just opens up a Pandora's box that we really cannot go down that road if we're going to survive in a country that is so multicultural, that has so many different people of faiths, religions, races. We have to figure out how to get along without looking at the color of our skin, as Martin Luther King said. Look at the content of our character instead.
Okay, good stuff. One other big 30,000-foot view question. A lot now is being investigated on the activity of these district court judges and their injunctions. I understand the legal part of wherever it is could go to the Supreme Court, but the jurisdiction of those district court judges, it would be something that has to be looked at by Congress. However, do you think this has gained any kind of attention of the Supreme Court, that they're overreaching?
Oh, I think the Supreme Court is definitely looking at the question of nationwide injunctions. I mean, they just had an argument last month dealing with that question. Now, whether or not they're going to resolve it is another matter. But I think the court recognizes that when a government agency is doing something unlawful, an injunction may have to issue to stop that during the pendency of the case, when the arguments are heard and full trial is heard and that kind of thing. But then the question is, can a district court in one district somewhere, either California, if it's President Trump being the one being sued, or Texas, if it was President Biden being sued, can one district court basically set policy for the entire nation? And there are times that where a issue before a court must have broad ramifications, that the injunction may go beyond the borders of that district court. But the Supreme Court really has to put up guardrails to make sure that the district courts are just not simply trying to make law for the entire nation and getting away with it without some kind of standards that just don't exist right now. So the Supreme Court's going to have standards for these nationwide injunctions at some point, and probably sooner rather than later.
So all along, this has been somewhat of an ambiguity in the system that
It
allows
has
the
been,
district court to
because
reach out.
yeah, because the rules that govern the federal courts give the district courts power to issue injunctions. Well, that's well and good, but nobody ever thought that we would see, when those rules were adopted, that we would see so many cases, dozens and dozens of cases, a few against the Biden administration and then the Trump administration especially. So many cases where so many district judges are issuing so many nationwide injunctions. And because this is somewhat unprecedented, I think we're going to see some guardrails, as I said, put on the ability to have these nationwide injunctions.
In a practical sense, Jim, these district courts are really overloaded. In fact, you need more district judges. I mean, there's so many cases in these district courts. But if they don't define district being a district geographic area, then these kinds of things can happen.
Oh, absolutely. I mean, the backlog in some of the district courts is tremendous. If you file a civil action in a district court, it's going to be years in some places before it even gets heard. And justice delayed is justice denied in a lot of these cases. So, yes, we do need more district judges, and Congress ought to figure out how to do that in a relatively nonpartisan way. That's the only way it's going to be done. And the district court's jurisdiction, what they can rule on, has to be limited as well. Now, most district courts do not have these nationwide injunctions put before them. They're generally the ones that are targeted are the district courts where the person bringing the lawsuit, the state, the environmental group, the anti-Trump group, or whatever, knows that they're going to get a friendly judge. So in those cases, in those districts where you know you're not going to get a friendly judge, these cases aren't being filed. Those judges don't have the same workload constraints then that those courts that have all these lawsuits filed in them do.
Amazing. All right, let's come back to some specifics here. Can you kind of unpack the court's decision in the 7-county infrastructure coalition versus Eagle County? This is a pretty interesting case.
Yeah, this is an amazingly significant case because it involves a National Environmental Policy Act. Now, when the National Environmental Policy Act, or NEPA, as many of us call it, was passed in the early 1970s, it was fairly modest. The idea was that agencies, federal agencies, and anybody involving a federal project would study the environmental impacts before the project would proceed. It wasn't something to shut down a project if the environmental impacts are there, but it just so we would know that there are environmental impacts to allow us to make better decisions, to allow the government to make better decisions that would better protect the environment. But that has morphed in time where more and more things have to be considered in an environmental impact statement. Fast forward to this case where 7 counties infrastructure was trying to build an 88-mile pipeline to bring oil from the fields north down to the ports, the Gulf of Mexico, and just to spur that 88 miles. But they did a thorough environmental impact statement. It was 3,600 pages long. It considered all kinds of effects, and it should have been enough. But they were sued by a variety of environmental groups and one of the counties that didn't want the pipeline. And the lower courts had said and ruled that they had to not only consider the impacts of the pipeline itself, all the land that it would cover, the wetlands, the endangered species that it might touch, all those kind of things, but it also had to consider all the upstream and downstream effects. And what that means is all the environmental impacts of drilling for oil that may eventually reach the pipeline, and the downstream effects of what would happen to that oil once it hit the refineries. What are the environmental effects of the refineries? And of course, what about the impact of burning the oil have on global warming? So this had to be put all into a environmental impact statement for an 88-mile pipeline. And it would have been daunting, impossible, tens or hundreds of millions of dollars more in study, even after they did the 3,600-page study. And it just, things like this just kill projects right and left where there's no limit to the amount of environmental impact that a project can have. It's the butterfly effect, right? If a butterfly sneezes in China, it's going to have an impact on the weather in California. So with that in mind, if you have to study every single environmental impact, secondary, tertiary, down the line, up the line, you're never going to accomplish anything because environmental impact statements would be just too expensive. And that was the whole point of this lawsuit. So the Supreme Court, in an 8-0 decision, unanimously ruled no, that's too much. Justice Kavanaugh wrote the opinion, and he essentially ruled that, look, you have to look at the environmental impacts of the project itself, but not all these downstream and upstream effects. And he said, if you have a system where NEPA, the National Environmental Policy Act, requires all this extra study, it's going to be something that stifles and stops. And in fact, it has been stifling and just outright stopping projects that need to go forward. We live in a complicated society. We need stuff to be built. And we can't have a statute that creates such an impediment and such roadblocks to building things. So it was an excellent decision. Again, it was unanimous, so it's not a right versus left thing. It was an instance where the Supreme Court, all of the justices, used some common sense. And this is a very common sense decision in 7 counties infrastructure versus Eagle County.
This is huge, absolutely huge. Who abstained?
Justice Gorsuch abstained. Of course, he gave no reasons that justices never do, but we can figure he comes from Colorado, where this came out of, and he may have had financial or personal interest in the pipeline company, the county, one side or the other in the case. So he, I think, fairly wisely recused himself. It made no difference to the outcome of the case.
Right.
And the court also said that, you have to have some kind of deference to agencies. It's not the old Chevron deference, but, give us a break. If you have a impact statement that's 3,600 pages long, it looks at everything and anything that deals with the environmental, give the government a break and let the project go forward.
Wow, this is huge. I got some questions on this. Let me take a quick break. Let me say to our viewers and listeners, check out Jim's professional website, pacificlegal.org. And then he has a personal website for his book, nowheretolive.org. Check that out and get a copy of his book, Nowhere to Live, The Hidden Story of the American Housing Crisis. And we're going to touch on that when we come back. We'll be right back. Okay, welcome back. Always an honor to have with us Jim Burling. Jim is the Pacific Legal Foundation Vice President of Legal Affairs, and his book is fast today. We'll talk about that in a minute. Nowhere to Live, The Hidden Story of the American Housing Crisis. There's a picture of the cover of the book available online. It does have a website, nowheretolive.org, and then his professional website is pacificlegal.org. These folks are your frontline warriors in your behalf. So check them out and support them. Jim, just one more thing on the NEPA case. This is a huge adjustment to so much down the road. I got to imagine, since the NEPA has been somewhat weaponized through the years, that this is a real blow for them. Out here in the West, we still fight this because we have these massive fires, and then we're not allowed to go in there and clean up the floor because of organizations like this. You kind of wonder if this is a little bit of a crack in that area.
Yeah, I hope it is. Look, I'm the eternal optimist, and I fully understand the problem that when you have these forest fires, you have this dead, dying timber you can't clean up because every time you try, you have an environmental impact statement that has to be filed, and then you have people suing over it, and the judge wants to be careful to make sure the environmental impact statement is full and complete and considers everything. And by the time you're done, the forest is burned down, several times sometimes the time it takes to do these. So I think this is going to have an impact on the ability of suing to stop. If you have an environmental impact statement, you have to consider the effects of global warming and what are those effects. On a forest, will that affect the ecosystem of and it just goes on and on and on. The number of things that courts will require you to study an environmental impact statement. And I hope the lower courts, get the message from a unanimous opinion of the Supreme Court that too much can be too much, enough is enough, and let's study the honest to God real impacts on the environment of what you're doing, but not make it so burdensome so you can't do anything, such as, as you point out, not being able to take care of the forests in order to prevent forest fires. And if there is a fire, after there's a fire, not be able to clean up afterwards to get that dead and the burned timber out of there.
Yeah, it's such an irony, if not hypocritical, because good stewardship would require for us to go in there. We all want to be good conservationists, and for us going in there and cleaning that up is a duh.
It makes, and frankly, that's what humans have been doing in the forest for millennia. Before white man came to the North American continent, the Indians used to regularly burn and clear out forests so they'd have more land for grazing deer. They knew that forests were not something that were static. They had to be managed. The Indians didn't have modern management tools of chainsaws and trucks, but they managed best they could. And we should continue to manage our forests, or else they will manage us, or management by disaster. And management by disaster is no way to do things. And hopefully the environmental impact statement study requirement has gotten easier now to make it easy for us to manage in some way other than waiting for the next fire to wipe things out.
All right, I want to come to your book for a few moments I have left. You wrote an op-ed series about the housing crises. How could you summarize the problem?
Yeah, so a series of Southern California newspapers, Orange County Register, San Diego Union Tribune, have picked up these columns that I'm writing, explaining about how government policies have created the housing crisis that we're in. For example, the column that ran a couple of days ago talked about the first zoning law in America, which came out of Baltimore. And I've talked about this a number of times at different groups. People are surprised to realize that in June of 1910, 115 years ago, when a black lawyer bought a house in a white neighborhood, there was a riot and every window in his home was broken. And Baltimore soon thereafter adopted the nation's first zoning ordinance, which prohibited black people from moving into white neighborhoods and vice versa, in a cynical hat tip to equality. Now, that was eventually struck down by the Supreme Court because it affected property rights. But as I continue in my series, then we had another series of zoning laws and zoning decisions that made it really easy to stop development of homes on people's property if those homes would cater to lower income people. So smaller homes, multifamily homes, apartments, all those things have been banned in large parts of America, designed to keep minorities and poor populations out of areas. But the result of that has been, and may keep certain neighborhoods really nice and pretty, but the result has been that it's very, very difficult to build housing. And it is so difficult that each year we have less supply and more demand. And the difference between supply and demand grows to the point that we have a housing crisis. And so the law of supply and demand is inexorable. And I talk about this in the book. And if you don't build enough homes, prices are going to go up. And if prices are going to go up, some people won't be able to afford a place to live anymore. And they have to double up, triple up, live in their cars, or the worst cases, live in the street sometimes.
I know you can talk long and hard about this. I'm noticing something. While they're not investing in homes because of prices and I guess interest rates, apartment apartment building and construction is huge. It's exploded. And you kind of wonder, is this the alternative of owning a home? And does this ultimately bring people into the city where they can be, it sounds conspiratorial, but they actually are more controlled by stacking them on top of each other?
Yeah, I mean, there is that subtext of building more apartment areas in cities because people in cities tend to be more left-leaning, and perhaps it's a way of eradicating people out of rural areas and suburbs. I don't think it's any kind of design to do that, but I think it is an effect that we have when
No,
we have
it's an effect.
taken away so much of people's property rights to build homes out in the suburbs, to build them in rural areas where it's pretty much impossible to build in rural areas, as you know, in Oregon. Uh, and so it forces people into cities, and it sometimes raises prices in cities, raises congestion in cities more than it would otherwise be.
All right.
So it's whenever you have government interference in the housing market in some way, it has unintended consequences, perhaps intended consequences, but it has consequences that really are negative across the board.
Jim, I'm out of time. I want to have you back. Let me say to our viewers and listeners, check out pacificlegal.org. Check out the book website, nowheretolive.org. He takes this subject and really unpacks it and does a wonderful job with it, available online as well. I also want you to head up a national referendum that everybody's taxes freeze on their home at the age of 65. See you, Jim.
Great idea, Gary.